All right, welcome. To kick things off for Module 1, we're going to talk about the case of Tinker versus Des Moines. All right, so this is the first case you're going to run into with your Module 1 case study. So let's just jump right into it. This took place in 1969. All right, so let's look at the focus questions. This is what we're looking for. Is free speech different for public school students than for the general population? Make sure to explain your response. Don't just say yes or no. Do school officials have the right or an ethical obligation to restrict First Amendment rights for students? Again, make sure to explain your response. And this one right here, you're going to use multiple cases. How have the courts shaped the issue of student speech over time? Consider changes in society as you discuss different court cases, not one, but multiple ones. All right, so let's move on. Let's learn about Tinker versus Des Moines. So what happened? Okay, so in December of 1965, three students they had planned to wear some black armbands in protest of the Vietnam War. Now, the principal got word of this. They decided to implement a policy that prevented students from wearing armbands for such a reason. If students did wear the armbands, they were going to be asked to remove it, and if they refused, they were going to be suspended. Well, two siblings, John Tinker and Mary Beth Tinker, along with Christopher Eckhart, wore the armbands anyway. And of course, they were suspended for doing so. All right, so what happened next? The parents of the students decided to sue the school district for violating their students' or their child's First Amendment right. Now, the district court sided with the school, basically saying that, they're went against school policy, so therefore they're not allowed to do it. In the courts of appeals, U.S. Courts of Appeals of the Eighth Circuit, they upheld the same ruling of the district court. So the parents of the students ended up appealing the decision, and it was picked up by the Supreme Court. So what is the big deal here? Okay, so the question is, does a prohibition against wearing an armband in public school as a form of symbolic protest violate a student's freedom of speech? This is your right protected under the First Amendment. Does this violate your right? So we'll see what the Supreme Court had to say about it. Now, the majority opinion was a 7-2 decision. So you had 2 dissenting opinions, and you had 7 siding with the majority. Okay, the justice that wrote the opinion was Justice Fortas, basically stating that students retain their constitutional rights, freedom of speech, while in public school. Justice Fortas, he basically stated students nor teachers share their constitutional right to freedom of speech or expression at the schoolhouse gates. That's a direct quote. Okay, so the expression from the students must cause material and substantial disruption to the discipline and educational function of the school. So that is the key there. Does it cause a substantial disruption? Does it prevent the school from obtaining its mission to educate the students? The school officials specifically targeted anti-war armbands and not other political messages. So that was a big factor in Fortas's decision there, is that the school was targeting people who were anti-war or against the Vietnam War, not necessarily protesting in general. See, other protests, other political protests, they weren't punished. Now let's look at the concurring opinion. Remember, the concurring opinion is someone that is a justice that agrees with the majority opinion, but they wanted to add a little point that they had as well. Now, Justice Stewart wrote that children are not guaranteed the same protections under the First Amendment as adults. So even though he was on the concurring opinion, he didn't feel like they had the same rights as adults. They were still limited, but in this particular case, the students were wronged by being suspended for something as simple as an armband. Now, Justice Byron White, he said that in another concurring opinion, there is a distinction between communication through words and communication through actions. All right, now let's look at the dissenting opinions. First, we have the dissenting opinion by Justice Black. He went on to say that it's a myth to say that any person has a constitutional right to say whatever he pleases, where he pleases, and when he pleases. Okay. He said the Tinker's armbands did indeed cause a disruption because it took the students' minds off of the issue of learning and put it on a very highly emotional subject such as the Vietnam War. Now, Justice Harlan stated that the motive of the school was very important here. He said they should be allowed to maintain order unless their motivation comes from a place that is not in the best interest of the students. So Justice Harlan believed that the school had the best interest for the students, so therefore they should be able to make rules like banning an armband. Now, so what we got from this case was something called the Tinker test. This is supposed to be used as precedent in similar cases as they arise in the lower courts or even to the Supreme Court eventually, which some did. Okay, so the school officials can discipline their students for expression, verbal or nonverbal, if it creates a substantial disruption to the learning environment. So that is the Tinker test. That's what we get from this case. So that is supposed to be followed later on. So here's a few things to think about. How does the Supreme Court determine if something is disruptive? Well, I think we've kind of determined that. Does something inhibit students from learning? Okay. Again, this can still be subjective though. It depends on your perspective. Is speech in school any different from speech in the workplace? Think about that. Can your parents go to work and say whatever they want without getting fired or sent home? Can a teacher stand up in front of the classroom and say whatever they want without getting sent home or fired or not asked back next year? No. No. In the workplace, you have certain etiquette that you have to follow, certain policies you have to follow. So I can't imagine that it's really too much different for an adult in the workplace than it is for a student in school. So think about it like that. Remember, the First Amendment says that Congress shall make no law abridging the freedom of speech. It doesn't say anything about schools. It says Congress. If you, when the students wore the armbands, did they go to jail? No, they didn't go to jail. They just got suspended. So that's just something to think about there. How is it different? And does the First Amendment mean you can say anything? Obviously not. Obviously there are some limitations, but what are those? That's something to think about, and that's something you will cover in later modules as well. So again, let's look back at the focus questions. Is free speech different for public school students than it is for the general population? That's just, if you're walking down the street, is it different? Is it different for the general population than it is for students in school? Make sure to explain your response. Do school officials have a right or an ethical obligation to restrict First Amendment rights for students? Do you feel like they do? Explain why. And also, how have the courts shaped the issue of student speech over time? Now, we can't answer this question yet because we've only covered Tinker versus Des Moines. So keep this in mind during the next videos and the other cases in Module 1 case study. All right? I hope this was helpful, and good luck on the case study.